Hey there, and welcome to your personal tutoring session. Listen, if you're a stressed undergraduate law student right now staring down what feels like an absolute mountain of revision, I want you to just take a deep breath. We've got this. Today, we are completely demystifying Chapter 4 of your contract law syllabus, so you can walk into that exam hall feeling absolutely confident. We're going to break down contractual terms, highlight the exact case law you need, and frankly, look at exactly what your examiners are desperate to see.
So here's our game plan for this explainer. 1. Sorting pre-contractual statements. 2. Incorporating express terms. 3. Classifying contractual terms. And 4. Uncovering implied terms. Think of this as your foolproof roadmap to perfectly structure your revision.
All right, Section 1. Sorting pre-contractual statements. Let's just dive straight into our first act and sort out the legal clutter of, well, everything that gets said before a contract is actually signed. Because in law, talk isn't just cheap, it is heavily categorized.
Now here's a massive exam tip for you. Memorize these 3 legal categories. The legal consequences of a false pre-contractual statement depend entirely on how the courts classify it. So if it's a puff, a totally boastful, over-the-top advertising statement that no one takes seriously, there's zero liability, nothing. If it's a representation, meaning a statement that actually induces a party to enter the contract but isn't part of the core agreement itself, liability falls under misrepresentation. But if that statement becomes an actual term, boom, it's a binding promise. If it turns out to be false, you have an automatic right to sue for breach of contract.
Moving right along to Section 2, incorporating express terms. How did those pre-contractual statements actually make it across the finish line and into the contract as binding express terms? Like, how do courts decide what's just a mere representation and what is a legally binding term? Well, the courts look really heavily at the importance of a statement to the person making the contract. A perfect example of this is the classic 1861 case of Bannerman versus White. Here, a purchaser of hops made a highly specific pre-contractual inquiry. He explicitly stated that he absolutely would not buy the goods if they had been treated with sulfur.
The buyer literally said, "If they have been treated with sulfur, I am not interested in even asking the price." This just brilliantly illustrates the legal standard. Because the buyer made this absolute condition so unequivocally clear right off the bat, the court ruled that the seller's false assurance wasn't just some passing comment. No, it was a fundamental breach of a contractual term.
Courts also look closely at specialist knowledge. Basically, if one party relies on an expert in deciding whether to enter a contract, that expert's statements are usually treated as terms. Think about it like going to a mechanic. In Dick Bentley Productions versus Harold Smith Motors, a professional car dealer falsely stated the mileage of a vehicle. Because the buyer rightfully relied on the specialized skill and knowledge of that dealer, the mileage statement was automatically elevated to a binding term of the contract. But what happens if a really specific verbal promise completely contradicts the standard written terms? In J. Evans & Son versus Andrea Mazzario Ltd., there was this written clause giving the transporters total freedom over how to handle cargo. But they also made a verbal agreement promising to transport a very specific machine below deck. Predictably, they put it on deck instead. A swell hit, and the machine was literally lost overboard. The court actually ruled that the specific verbal assurance overrode the standard written document.
You have to remember, though, signatures are incredibly powerful in contract law, which brings us to a crucial case you definitely need to know: Lestrange versus Grokov. In this one, the claimant signed a document without actually reading the exclusion clauses buried inside it. Let's be real. We've all been guilty of skimming the terms and conditions online, right?
Well, Scruton LJ give us the ultimate exam weapon here, stating, when a document containing contractual terms is signed, the party signing it is bound and it is wholly immaterial whether he has read the document or not. Write that down, highlight it, double underline it, and use it in your problem questions. Bottom line, if your client signs it, they are legally bound.
Let's pivot for a second to the baseline common law rule for written contracts, the Parol evidence rule. Essentially, this rule dictates that where a contract has been put into writing, outside or extrinsic evidence is totally inadmissible if you're trying to add to, vary, or contradict its terms. The law just presumes the written document is the entire agreement, the whole shebang.
However, if you want to score those high marks, you've got to show the examiner you know the nuances. You need to cite these 2 specific exceptions where the courts will actually allow outside evidence. First, to allow the rectification of a true agreement. Like if the written document clearly doesn't accurately reflect what was actually agreed upon, as seen in Webster versus Cecil. And second, to prove a collateral or parallel oral contract exists alongside the written one. That's demonstrated beautifully in City and Westminster Properties versus Mudd.
Okay, Section 3, Classifying Contractual Terms. Next up, we really need to tackle the hierarchy of terms. Because in the eyes of the law, not all promises hold the exact same legal weight. We have conditions, warranties, and innominate terms.
Wait, what's the exact difference between a condition and a warranty? I hear this question from stressed undergrads literally all the time. It can totally feel like pure semantics, but trust me, getting this wrong in a problem question will cost you dearly. So let's break it down side by side.
So, here is the absolute crucial difference. A condition goes to the very root of the contract. If a condition is broken, like in the case of Poussard versus Spears, you can terminate or repudiate the whole contract and claim damages. A warranty, on the other hand, is of lesser importance. If a mere warranty is broken, as we see in Bettini versus Guy, you are unfortunately stuck with the contract. You cannot repudiate it, you can only claim damages for the breach.
But as you're quickly learning, the law isn't always perfectly black and white, or easily categorized right from day one. Which brings us to a massively important case, Hong Kong Fur Shipping Co. Ltd. versus Kawasaki Kisen Kaisha Ltd. This 1962 case introduced the highly flexible wait-and-see approach of the Innominate term.
Instead of rigidly classifying a term as a condition or a warranty right at the start, Lord Diplock established a vital test question. He asked, does the breach deprive the party of substantially the whole benefit which it was intended that he should obtain? Courts are going to look at the actual real-world consequences of the breach. If the answer is yes, it's treated like a condition and they can terminate. If no, it's treated like a warranty and they only get damages. Pretty clever, right?
All right, Section 4, Uncovering Implied Terms. Let's move into our final act for this explainer and uncover the hidden DNA of a contract, the implied terms. These are the terms that are not expressly written down or spoken out loud, but are nevertheless 100% legally binding. Courts will legally inject terms into a contract in two main ways. First, terms implied in fact to give a contract business efficacy. Think of the famous officious bystander test from the Moorcock. Imagine an annoying bystander suggested a term to the parties making a deal, and both parties immediately rolled their eyes and said, "Oh, of course, that term is implied." Second, we have terms implied in law. This is where courts impose terms to regulate specific, standardized relationships, like making sure landlords take reasonable care of common areas for their tenants, as established in Liverpool City Council versus Irwin.
Additionally, established trade customs or local usages can just naturally imply terms into a contract. This works provided the contract is actually silent on the matter, and the custom doesn't directly contradict whatever is expressly written. You'll definitely want to cite Hutton versus Warren or Les Efforteurs Renew's essay versus Walford to back this up in your essays. Finally, memorize these 4 key sections of the Sale of Goods Act 1979. This is your statutory cheat sheet. Parliament stepped in to imply terms automatically into consumer contracts. Referencing Section 2 for title, Section 3 for description, Section 4 for satisfactory quality, and Section 5 for sample is an absolute guaranteed way to score major points on any consumer problem question. And on that note, I'm going to leave you with a provocative question to really test your legal instincts right before your exam. Let's say a seller explicitly points out a defect to you before you buy something. Can you later turn around and sue them, claiming the goods aren't of satisfactory quality under the Act? Review Section 14, specifically subsection 2C of the Sale of Goods Act to find your answer. You've got the tools now. We've covered the major cases, so keep reviewing, stay calm, and good luck out there.